In light of the big win in Cargill versus Garland dealing with the bump stock ban, we need to talk about lessons from the past and next steps. Specifically, we want to talk about, and I'm going to give you some history here, of why the anti-gunners were so desperate to ban bump stocks through Congress. It had nothing to do with bump stocks. It had everything to do with banning better triggers, better firearm technology, banning AR-15s, and the like. I want to talk to you also about going forward, because the anti-gunners are going to try, as an excuse to get around Cargill versus Garland, they're going to try to do other things to ban ultimately AR-15s. And I want to talk about this. And last but not least, I want to talk about machine guns specifically. Is it possible, as we've discussed before, to use the dissenting opinion by then Judge Samuel Alito on the Third Circuit Court of Appeals to somehow alter or knock out the Hughes Amendment, which in 1986 said you can no longer have new machine guns that were built after 1986? Is it possible that this Garland versus Cargill case, in conjunction with the dissent in the Rybar case by then Judge Justice Alito, is it going to allow us to have some opportunities for machine guns going forward? We're going to break it all down when we come right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed: What the 10/7 Attacks Teaches Americans About the Right to Bear Arms. We must always learn our lessons about the importance of an armed citizenry, private self-defense-oriented gun rights, and we must also learn from the mistakes of others that do not go down that path. And the Israel example is a powerful one, which I detail in the new best-selling book, Israel Disarmed. Check it out on Amazon. All right, folks, so we have to continue our analysis of this very important case of Michael Cargill. Congratulations, Michael Cargill, and to the new Civil Liberties Alliance. Follow them both on Twitter. Congratulations on your big win against Merrick Garland and the ATF. We've talked a lot about why this is such an important win, but I now want to talk about a little bit of history here. So we don't want to make mistakes from history, and we also, of course, want to learn from what's happened in the past to make sure we do good in the future. And I want to talk about what may happen in the future, maybe some of the good and the bad and the ugly going forward because of this Cargill decision. To begin with, let's start with the concurrence, which has gotten a lot of attention by U.S. Supreme Court Justice Samuel Alito, who's very good on the Second Amendment. He is never going to be an issue on the Second Amendment. However, some people have pushed back and said that Justice Alito has been historically respectful of the Constitution and the Bill of Rights and the Second Amendment, but he wrote this concurring opinion where he basically says that Congress should go out there and change the law to effectuate a bump stock ban. Here is what Justice Alito wrote in his concurring opinion in support of Garland versus Cargill. Justice Alito writes, quote, "There is a simple remedy for the disparate treatment of bump stocks and machine guns. Congress can amend the law, and perhaps would have done so already if ATF had stuck with its earlier interpretation. Now that the situation is clear, Congress can act." That's very important language. Very important language. Now, some of you think that's saying that Justice Alito wants a bump stock ban. Maybe he does, maybe he doesn't. I don't know. It doesn't matter. But what you need to take away from that is it's clear that the Supreme Court is no longer going to allow administrative agencies like the ATF, the FBI, the EPA, the FDA, and so on to make law by simply reinterpreting old laws. They're going to force, going forward, Congress and we, the people, to do our job by enacting legislation if there's some legislation we want to enact. Now, again, there's nothing that Justice Alito was saying here about whether or not a bump stock ban would be constitutional under either the Commerce Clause or the Second Amendment. He's not getting into any of that whatsoever. In fact, it's quite possible that he might view such an action to be inconsistent with the Commerce Clause. We'll get to that in 1 minute with something he wrote in a case back in, I think it was like in the mid-1990s, the Rybar case out of the Third Circuit, where he speaks to this issue about gun control laws possibly being unconstitutional, not necessarily because of the Second Amendment, but because the way they were enacted violates the Commerce Clause of Article 1 of the United States Constitution. But before we get there, let's make it clear, and this is where there's disagreement about this. I am fully pro-Donald Trump. Look, I got criticisms of everybody. I got criticisms of Donald Trump and his administration. I get it. But there's no doubt that when it comes to our Second Amendment rights, it's clearly the case that President Donald Trump, given his justices and judges he's appointed to the Supreme Court and to the lower courts, is far superior on the Second Amendment than Joe Biden is ever in any respect. So in terms of picking between Trump and Biden, if you support the Second Amendment and that's your issue, then Donald Trump is clearly the right choice, period, full stop. But again, as I've reminded you on this channel, I think the Trump administration made a strategic choice, as did the NRA, that the reports indicate the NRA supported this, to ban bump stocks specifically through ATF reinterpretation of what a machine gun is and whether or not a bump stock falls within the definition of machine gun. And the reason was that they wanted to foreclose possible legislation by anti-gunners in Congress to try to pass an amendment to the existing machine gun laws, which would have been very bad, not only because it would have broadened the definition of machine guns to encompass things like AR-15s and other things like matched triggers, we'll talk about that in 1 second, but it also potentially would have wiped out decades and decades and decades of favorable rulings and letters and positions taken by the ATF, because it would have given them a new excuse, if you will, to reinterpret everything else, because they say, well, we're just interpreting the new statute. All of our prior letters, our prior opinions from the past definition of machine guns are no longer valid. We have to redo them all. And the concern, I think, was that the modern administrative state, the modern ATF, all of these things are much more anti-gun in Washington, D.C. than they were decades ago. So you don't want to give them an excuse to make up new laws through regulation or otherwise. And if you had amended the definition of machine gun to encompass bump stocks, you were basically just open up Pandora's box to all sorts of other nutty anti-gun efforts, not just legislatively, but also with regulation. Now, just anti-gun Senator Dianne Feinstein undeniably understood this, which is why she specifically wanted to ban bump stocks legislatively. That is what she was pushing for. Okay? And here is, just so you understand, here is what Stephen Halbrook, for example, who testified against the bump stock ban, had to say in summary about the proposed bump stock ban in 2017. The misnamed Automatic Gunfire Prevention Act would apply only to semi-automatics, not automatics. Its ban on any part of that functions to accelerate the rate of fire of a semi-automatic rifle essentially bans any semi-automatic rifle. That's right. Its ban on any part of that functions to accelerate the rate of fire of a semi-automatic rifle essentially bans any semi-automatic rifle, as a mere trigger adjustment for accuracy will increase the rate of fire. Since automatic rifles are commonly possessed for lawful purposes, this would violate the Second Amendment. The terms are vague in violation of due process, as a person has no way to know or measure what may increase the rate of fire. Bump stock device is not defined, and 10 years imprisonment is imposed for mere possession without a willfulness requirement. This would be an unprecedented ban lacking a grandfather clause or an amnesty for registration. So there you have it. The goal of the bump stock ban through Congress had nothing really to do with bump stocks. And that's something the Trump administration and the NRA must have understood back then. They must have realized that if you use the bump stock ban in Congress to expand these definitions, very, very bad things would occur, including to like improving your AR-15 with like a better rifle or better scope, whatever it is, risk the possibility of increasing the rate of fire and putting you in prison for 10 years. So that was simply not a good idea. And now, of course, what's going to happen going forward is that the Congress is going to try to use this as an excuse to ban bump stocks and revisit these issues of expanding the definition of machine guns, but hopefully that doesn't occur. Now, I should note there's another danger here that we need to be paying attention to. We've talked about this before. In 1934, the National Firearms Act was enacted. It was a taxing provision. It was enacted because under the Congress's taxing authority. And remember, in 1934, machine guns were not banned. Machine guns were taxed. And it was viewed as an exercise of Congress's authority, legal authority, to tax things. That is exactly what it was all about. If you look at the early legislation and you looked at the court cases from the 1930s, it was all about taxing authority. But then we know what happened in 1986 as part of like that gestalt of legislation that was enacted, including the Gun Owners Protection Act. Some of that was good. But in 1986, Congress enacted the Hughes Amendment, which banned the mere possession of machine guns that were not possessed as of the date of the enactment of the Hughes Amendment. You hear what I just said? So in 1934, the National Firearms Act taxed the possession and required registration of machine guns. But in 1986, the Hughes Amendment was enacted that says that you're not allowed to possess a machine gun unless that machine gun was already in existence in 1986. And here's the key. That Hughes Amendment, as I've discussed before, is likely unconstitutional under the Commerce Clause. The reason why the Hughes Amendment is likely unconstitutional under the Commerce Clause is because there's no element to interstate commerce. In fact, the testimony in 1986 was really indicating that banning machine guns would not impact interstate commerce in any respect because they're never used in crimes. Here's a fascinating quote from the testimony of Stephen Higgins, the ATF director in 1986, about how people just don't use machine guns in crimes. Check out this. Quote, 118,000 machine guns are registered in our files. I can count probably in less than my fingers the number of cases in which those have been used in a crime or crime of violence. And as Stephen Halbrook pointed out recently in a Volokh Conspiracy blog post, he points out that obviously cannot possibly impact interstate commerce when it's so rarely used in crimes, these machine guns. Nevertheless, it was enacted. And by the way, this was not lost on then Judge Samuel Alito, who wrote that concurrence. You see the connections? So Justice Alito was saying, hey, change the law of Congress if you want to, give it a go. But in contrast, Justice Alito today, obviously that's what he said as justice, but when he was a judge back in 1996 in the United States versus Rybar case dealing with machine gun possession, he specifically raised the question and thought that the Hughes Amendment was unconstitutional because it went beyond Congress's powers. Sounding familiar? Yes, it should. Here's what then Judge Samuel Alito wrote about the Hughes Amendment. Listen carefully. We've covered this before, but you got to be reminded of it right now. Quote, the statutory provision challenged in this case, the portion of 18 U.S.C. 922.0 that generally prohibits the purely intrastate possession of a machine gun is the closest extant relative to the statute struck down in Lopez, which made it a federal offense knowingly to possess a firearm in a school zone. Both are criminal statutes that regulate the purely intrastate possession of firearms. Both statutes, departing from the mode of prior federal criminal statutes governing firearms possession, lack a jurisdictional element. That is, they do not require federal prosecutors to prove that the firearms were possessed in or affecting interstate commerce. And in passing both statutes, Congress made no findings regarding the link between the intrastate commerce regulated by these laws and the interstate commerce. That responsibility requires us, as judges, to invalidate the statutory provision at issue here in its present form. So, again, is now the time to start thinking about knocking out the Hughes Amendment? I think it's possible. I'm not sure I would start litigating right now this issue, but let's see where things are in the next year or so as we find out who wins the presidential election, we find out who is in Congress, things like this, and then we see what happens with the courts, specifically the Rahimi case and some of these other Second Amendment cases. But we need to pay attention to this because I do think that Justice Alito, in his concurrence, saying Congress has the authority to act and do this, but at the same time, he's indicated that the banning the mere possession of an item is likely unconstitutional under Article 1 of the U.S. Constitution because and if there's no interstate commerce component of that. So it'll be interesting to see how all of this works out. But as we move forward, again, we want to keep in mind that why the Trump administration went the executive action route versus legislation. We must keep in mind that the purpose of the Bumpstock ban legislation in Congress by Dianne Feinstein had nothing to do with Bumpstocks and everything to do with trying to get more guns and gun parts and gun equipment and gun accessories and essential components of firearms banned by expanding the definition of machine guns and to eliminate all the pro-gun, which was really just accurate stuff, but all the pro-gun opinions and letter opinions and whatnot from the ATF for the last many, many decades, so that it gave the anti-gun in the deep state and regulatory agencies the opportunity to rewrite all this with the excuse like our old definitions don't apply because we have new definitions given to us by Congress. We have to throw out the old and embrace the new, but all the new stuff will be more and more anti-gun because that's who's in Washington today, unlike, let's say, in the 50s and 60s where you actually had people that like guns working in the federal government. That is no longer the case today. And again, last but not least, we must realize the good news is that the Supreme Court justices have made it clear if they want to ban guns, if they want to mess with guns, they have to do it through Congress. Very difficult for them to do in today's world, obviously. And they can't just allow the ATF to go out there and redefine terms, redefine things because they want to, because it advances Joe Biden's anti-gun agenda. They have to go to Congress, and that is exactly what we want them to do because, again, it's very difficult for legislation involving these issues to get through Congress. So that is exactly where we want the issue to be raised, as opposed to these unelected bureaucrats in Washington, D.C. doing the bidding of the anti-gunners and the Biden administration, which is basically one and the same. All right, folks, there you have it. Hope you learned something here today. Make sure you subscribe here. Don't forget to follow me on X at 4 Boxes Diner, and we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.